Mr. Aldana, let me say to you that each time you've had a chance to describe your circumstance to me, I've expressed my condolences for you, and I sincerely mean that. I'm a very private person. I don't say things about my private life on the bench, but I mentioned to you specifically the death of my parents by cancer because I want you to know that I empathize with your circumstance, and I know that's not an easy thing to go through. And I want to compliment you, Mr. Aldana. You've been a lawyer assigned to my courtroom for the entire time I've been here, and your work has been exceptional. You are a credit to public defense. And, you know, during the time that all this has happened, I've been reflecting on the many cases you've had before me and some of the significant cases you've had and some of the significant outcomes. And the fact that those cases turned on the quality of your representation. I remember the attempted murder case that you had in front of me that I referenced in one of the rulings, and the tenacity with which you litigated the competency of that individual. And you were right to question that competency. I remember domestic violence case where you were the defense counsel, Mr. Stars was the prosecutor, and the ultimate disposition of that case reflected a significant movement by the state in terms of their view of the significance of the case. The charges were dramatically reduced from felonies to misdemeanors. The state didn't recommend any additional jail time, and that was a credit to the hard work that you did in bringing all the facts to bear to the court. And I remember the case of a local attorney that was charged with really significant felony cases. The state didn't only throw the book at this guy, they threw the bookcase at him. That case was ultimately, you brought a motion to suppress evidence, which I granted, and eventually the case was dismissed. And I think that was the just outcome. And that happened because of the hard work that you did. So I don't want anything that's happening in this case to cause you to think that I don't respect the quality of lawyer that you are. And in fact, the record in this case, as I've alluded to over and over again, overwhelmingly establishes the really diligent efforts that you've engaged in. You've made sure that the defendant received all the discovery. You've made sure that the pertinent witnesses were called as witnesses at the preliminary hearing, and you locked them into their testimonies under oath. That's great lawyering. And you've identified every single conceivable legal motion that could be filed in this case, and you filed them, and they're very well written. I've read all of them. And you filed reply briefs, and you know, I indicated in the last order that the case is in good shape because of the hard work that you've done. And so I wanted you to know that. Because of everything I've just said, all the work that you've done in front of me, you developed a reservoir of trust with the court. And that's really important as a lawyer. And that reservoir of trust impacted rulings that I made in this case. And I've described those rulings multiple times now as being unprecedented. You were concerned, in fact, alleged that the state had been withholding discovery. And you asked to review all of the state's internal email communications. That's an extreme position. I think I mentioned to the parties that in the entire 28-year prosecutorial career that I had, only one time did ever any judge require any internal work product communications of a prosecutor that I'm aware of be turned over. And it was in a very limited scope. So this was a really significant issue. But what I did was I agreed to do an in-camera review of it. And you know, to his credit, Mr. McBride has never criticized that ruling, but I'm sure he took umbrage at the court doing that. But I did it because I trusted that if Ben Aldana was raising this issue, I should probably look into it. The other thing is the decorum order that we talked about today, that's another extreme order. Like, I'm unaware of any court that's ever entered an order that's that broad. And, you know, the counsel for the television station, was here today and was very concerned about their rights. But I did that because I credited the concerns that you raised about the defendant receiving a fair trial. And I agreed with you. I want to make sure, and even though you may disagree with it, I have made every ruling in this case because I think it was the right thing to do. I've tried to understand the law and correctly apply it here and try to be fair to both parties. And so that's the way that I see the general context of this situation. And so I want to make sure you were aware of my perspective about the quality of representation. And I would have guessed that you would think that, because you'll remember that after that, the case against that lawyer was dismissed, you and I had a conversation where I specifically complimented you on the quality of your work. And you and I had a discussion about what amount of money that lawyer would have to pay a private lawyer to do the work that you did in that case. Do you remember that?
Yes,
Yes.
Your Honor, I do.
Anyway, the context in which this happens is that this car accident happened and these two children were killed. And we've been trying now for over 2 years to get all the discovery, to get everything litigated, to get this case fairly tried in a timely way. And that's what I'm trying to do. Okay, so I want the parties to understand that that's what I'm trying to do, is just get this case over this finish line in a timely way. And I've tried to identify all the many competing interests that are involved here. And your circumstance, Mr. Allen, is one of those competing interests. So anyway, I appreciate everybody's hard work today. We're making progress to get this case to trial.